everyone to the afternoon. Thank you for the introduction. My name is Zinja. I work in political science. Thanks everyone for coming. I'm sure either you've traveled and you're tired or you're exhausted, but I promise you'll be rewarded. Our first speaker is Dr. Amanda Alexander. She is a lecturer at the Australian Catholic University, and her research tackles the history of international humanitarian law with a focus on change in international law. Her recent publications include, but are not limited to, several articles, some of which are a short history of international humanitarian law in the European Journal of International Law. Another one is International Law, Post-Colonialism and the Geneva Protocol in the Melbourne Journal of International Law, and The Good War, Preparations for a War Against Civilians in Law, Culture, and the Humanities. The title of her talk is The Vietnam War and the Civilian Combatant Distinction in International Humanitarian Law.
What I'm talking about today is about the effect of the Vietnam War on the creation of the civilian combatant distinction in international humanitarian law. So today, this distinction between the civilian and the combatant is considered extremely important, probably one of the central concepts in international humanitarian law. The way the distinction is understood today, I would say, is encapsulated in the International Committee of the Red Cross's list of the customary rules of international humanitarian law that it published in 2005. So in these rules, the principle of distinction is rule number 1. In rule 4, combatants are defined as members of the armed forces, and in rule 5, civilians are defined as those who are not members of the armed forces. Under Rule 106, in order to have prisoner of war status and to be treated as a combatant, combatants have to identify themselves preparatory to attack. Now, these rules reflect in a slightly vaguer manner the already fairly vague rules found in the Additional Protocol 1 to the Geneva Conventions. As such, the Additional Protocol could now be considered customary law as well as treaty law, that meaning that it would bind even non-parties to the Additional Protocols. And I think it's more than that even. These rules that are found in the Additional Protocol are now considered to be obvious, unquestionable definitions of the civilian and the combatant. And when parties object to them or fail to apply them properly, it's often seen as a political move, which it usually is a political move, but my point is that the definitions themselves are not necessarily neutral or obvious definitions. They are one particular way of defining civilians and combatants, and those definitions were created in a particular environment of political controversy and compromise. Now, this environment was the diplomatic conferences on the reaffirmation and development of international humanitarian law applicable in armed conflicts that took place between 1974 and 1977 and resulted in the additional protocols to the Geneva Conventions. And of course, it was the array of conflicts that were going on in the background that also influenced what happened at these conferences. So in this talk, I'm going to be particularly focusing on the effect of the Vietnam War. I think Ehab and Jessica spoke very well about the effect of the Israeli conflict on the background too. The Vietnam War in particular was a very good example of the kind of war that the ICRC wanted to draft rules to deal with. And it was also particularly important in shaping some of the positions on the possible laws of war that came into play at the conference. And there were a variety of positions on what the laws of war could be or should be, and how they might picture the combatant and the civilian. There's at least 3 positions which I'm going to discuss in this talk. 3 different approaches to this distinction, and none of these approaches actually gave unproblematic protection to civilians. So the first important approach to be aware of, I think, is the traditional position of the laws of armed conflict. Now, it was often stated before the diplomatic conferences and at the diplomatic conferences, and it's still stated today, that there had been a long-standing principle of protection for civilians in international law. And it was also stated that there was no legal regime to deal with guerrilla warfare. It was suggested quite often that the kind of guerrilla warfare that was confronting states before and during the diplomatic conferences was something new. Now, I have argued that this wasn't the case. So irregular warfare, as it was called, the problem of irregular belligerence, was a big issue at the Hague Conventions, at the conferences to draft the Hague Conventions. The states, this is at the beginning of the 20th century, so the states negotiating these conventions had experienced irregular warfare, both in Europe, it had been a big issue in the Franco-Prussian War, and they had experienced it in their colonial wars. It wasn't a new experience for them. The thing was that most of the states at the conferences really didn't like irregular warfare. They thought it was absolutely anathema to the proper conduct of warfare, and they deliberately drafted rules of warfare that denied any protection to irregular combatants. These rules were retained in the 1949 Geneva Conventions, with a slight expansion to allow for the inclusion of the sort of resistance movements that looked like the French resistance, so they would have some protection. Throughout this period, it was absolutely understood that irregular warfare endangered civilians or private citizens, as they were called, and in fact, and partly endangered them because it was considered acceptable in international law to undertake reprisals against a civilian population if members of the population seemed to be engaging in irregular warfare. Now, as this provision shows, there wasn't much protection of civilians in international law, in the laws of armed conflict either, not the sort of protection that we now think that civilians should have. There wasn't even a civilian-military distinction found anywhere in treaty law, except for the 1923 Hague Rules of Aerial Warfare that were never actually agreed to. The only real protection we find for private citizens, civilians in the Hague Conventions is the prohibition of bombardment of undefended towns, which is a distinction that made no sense once aerial warfare came into play anyway. Under the rules of law, the laws of war before 1977, civilians could be starved in warfare, and they were. They could be subjected to aerial bombardment, and they were. They could be taken hostage, they could be subject to reprisals, and all these things happened. There was generally an understanding that civilians or private citizens, that their fate was tied to their state, right? Now, the world wars were total wars, and it was absolutely understood that during those wars, the success of the state was dependent on its civilian population, and the fate of the civilian was dependent on its state. So my point is that the existing laws of warfare, these laws that were drafted predominantly by Western European states, did not provide a clear understanding of civilian immunity. Culturally and legally, there was a tradition of associating civilians with their state and only providing limited protection for them for that reason. So that was one position. But there was another Western position. So as I said, the ICRC and Western delegates said during the conference that there was protection of civilians and no law about guerrilla warfare. So I have wondered why these statements were made when it seemed clear to me that there weren't rules about civilians and there were rules about guerrillas. And my feeling is that this point of view came about because of the cultural shift, which I think was discussed partly by Maddie in her talk, but that there was, because of the anti-war protests about Vietnam, because they used this language of law to such a large extent, because, as Maddie said, they turned the standards of law into moral standards that said, well, it said if you believed that the law was moral in some way, that the law is meant to be legitimate, it was very hard to say that the law provided no protection for the sort of freedom fighters who were fighting in Algeria, say, or the guerrillas in Vietnam, or that you could say that the laws of war allowed for the sort of attacks on civilians that were taking place in Vietnam. It became harder and harder, not just to defend the laws of war as they existed, but even to say that they allowed these things if you wanted to see the law as legitimate in any way. So as a result, these delegates said, and commentators said, there was no law on guerrillas, and there needed to be. And they said there were rules on civilians, and they just needed to be reaffirmed in international law. So as a result, when a lot of the delegates from Western states went to the conference, they had created an opening for new rules, and they were expecting to write in new rules about civilians or reaffirm the rules about civilians and write new rules about guerrillas. So that is, they went in a position of readiness to make changes, even when they didn't see it as changes. But still, the changes they wanted to make were still fairly constrained by the terms and more the concepts of the sort of unacknowledged pre-existing law. So Western delegates wanted to provide guerrillas with a little bit of protection, but just enough protection really to encourage guerrillas to follow the laws of war, to protect civilians more, and to identify themselves, because they thought that was important. They were also expecting Western states to respect civilians a little more too, though maybe not as much as you would expect when it came to the details of drafting the provisions. But it seems to me that the image they had of warfare, of what a correct way of waging war was, that they wanted to reproduce with these rules, was simply making irregular guerrilla warfare look a little bit more like the kind of regular warfare that was already covered by the rules of war. So they wanted to make guerrillas, make irregular combatants a bit more like regular combatants, like encourage them to identify themselves, right? So that they're no longer really guerrillas. And they wanted to make civilians a bit more like civilians and protect them a bit more. So it's still a bit ambivalent on the amount of protection they're going to give out. Okay, so these are the two Western positions. The first, which sees the civilian as part of a state and only gives minimal protection to civilians and none to regular combatants. And the second, which wants to make irregular combatants more like regular combatants and protect everyone a bit more. Now, there was a third position, which was the position of national liberation movements, which was put forward fairly strongly at the diplomatic conference by North Vietnam. And this position went even further than the traditional Western position in associating the civilian with the nation or the people. And I do say as an aside, you often see this association of the people with the army and the resistance as some kind of, I guess, anomaly of the national liberation movement. But, you know, I do think it's important to realise that it is part of this Western cultural and legal experience too. Anyway. So the Vietnamese communist strategy necessarily involved seeing the people and the military as the same. The resistance war is a people's war. The revolutionary literature talks about the whole nation in arms, about the fact that each person is a soldier, each village a fortress. It said that, you know, their method of warfare was necessarily guerrilla warfare, and guerrilla warfare necessarily involved this association between the people and the army. So it said, Chin wrote that the people are the eyes and the ears of the army. They feed and keep our soldiers. It is they who help the army in sabotage and in battle. The people constitute an inexhaustible source of strength for the army. So there's no distinction here between civilian and combatant. Now, for the communists, this type of warfare may have been illegal under the laws of war, but that didn't matter. It was still just. So for a national liberation movement, there's none of that sort of dissonance that I think Western lawyers felt, where they couldn't acknowledge a law that seemed so unjust. Like, it's, you know, for these people, it's much easier to say, look, the law says this, but it's unjust. You know, a just war is a war that's fought against oppressors and conquerors to safeguard the freedom and independence of peoples. And if the obvious way to do this is through guerrilla warfare, then that's fine. So for North Vietnam and other socialist and third world states, the diplomatic conference was an opportunity to make a statement about the justice of such wars and to provide extra protection for the people who fought in them. So, because there were these three different positions about the nature and the purpose of the laws of war and the role of the conference, there were obviously extensive disagreements and difficulties at the conference. So the first session was preoccupied with the question about the status and justice of wars of national liberation, and the whole conference nearly fell apart over this problem. It was eventually resolved, as I think we've already heard today, with the acknowledgement that wars of national liberation were international armed conflicts, and so covered by the additional Protocol 1. But once this was resolved, the question of combatant status became equally controversial. So as I said, the US and other Western delegations were ready to write new laws to fill what they saw as a gap, but they also believed that combatants had to distinguish themselves in order to protect civilians. In fact, the US delegates said that a combatant who deliberately fails to distinguish himself from other civilians while engaging in combat operations has committed an extraordinary violation of the laws of war because he is prejudicing the protection for other civilians. However, North Vietnam and some other post-colonial states argued that members of national liberation movements should never have to distinguish themselves. Firstly, because it simply isn't fair to expect ill-armed, repressed groups who are fighting against imperialist aggression to have to comply with such restrictions. Secondly, they said a principle of distinction didn't really protect civilians. It simply gave imperialist aggressors an excuse to attack civilians in reprisals for what were unavoidable infringements of the law. Also, finally, they said that the historical material necessity of national liberation wars made the whole concept of distinction irrelevant. So the National Liberation War was a historical material necessity. It necessarily required guerrilla warfare, and so necessarily had armies that were inseparable from the civilian population. So this question of when and how combatants should distinguish themselves took 2 years to resolve at the conferences. And even then, it was only through a lot of hard work, especially by the US delegates, and a final compromise proposed by South Vietnam, that a solution was reached. So this compromise avoided the standoff over when combatants should distinguish themselves by requiring it only during military engagement and during military deployment. Now, there was no shared understanding of what deployment meant, and Aldrich suggested that it was this ambiguity about when they should have to distinguish themselves that made the term acceptable to all delegates. So combatants were also encouraged to follow the laws of war, but the article also said that even if a combatant failed to meet those requirements, he should still be given protection equal to those given to prisoners of war. So this compromise and the provision that resulted was enough of a compromise to be adopted by 66 votes to 2 with 18 abstentions, but it was too much of a compromise for any of the delegates to be that happy. All of them recognised that it was not a very satisfactory result. They all referred to it as a compromise when explaining their votes. Many states complained about the ambiguity of the provision or were concerned that it had reduced the protection for civilians. North Vietnam was not happy because it felt that it had not gone far enough in protecting guerrillas. So no one was really happy, but everyone was tired of negotiating, and the article was accepted and written into the additional Protocol 1. So we have this kind of problematic, controversial definition of the combatant. Meanwhile, there's also a definition of the civilian written in, but obviously the definition of the civilian is dependent on who is a combatant. But everyone was very happy with the definition of the civilian, and there wasn't any controversy about it. So the ICRC had produced a draft article that defined civilians as any person who is not a combatant. And this was the first time civilians had been defined in this way. They'd been defined at all in the legal document. The ICRC described this as a negative formula, and they recognised that it was a novel way of thinking, of doing it, and that there were other ways of thinking about civilians, but the article was easily accepted by all the delegates. In the same way, the draft article that provided in general terms for the distinction, so the protection of civilians so that we don't target civilians, was accepted, and it was proclaimed as a reaffirmation of customary international law. So there was a lot less consensus when it came to the details of protection. Reprisals, the ability to continue to carry out reprisals against civilian objects was something that was argued over a lot by delegates. But eventually, the conference succeeded in providing what were really unprecedented protections for civilians. So civilians could no longer be starved, they could no longer be subject to reprisals, area bombardment was prohibited. So in this way, the diplomatic conference changed the legal meaning and protection of civilians and combatants, but it did do so in a way that was fairly contested in combatants, and was kind of ambiguous and paradoxical. So civilians were defined as not being combatants and granted increased protection, yet at the same time combatants were defined in a way that meant they could also be civilians, at least some of the time. So in this way, the Additional Protocol 1, which had aimed at expanding the protection of the civilian, at the same time obscured civilian status to some extent, and with it claims to protection. So these paradoxes, I would argue, are largely due to, firstly, the attempt to bring together such different ideas of what correct, just warfare is in one document. And secondly, due to the paradoxes within the Western position. So on the one hand, there's this diminished ability by Western states to defend the traditional precepts of law, but they're still kind of committed to the conceptualization of law that those provisions were there to ensure. And at the same time, there's a commitment to making law more humanitarian by improving the protection for both civilians and combatants, but it's very difficult to kind of increase the protection of both without obscuring the differences between them. So the drafts of the protocol were accepted, but the problems within it soon became apparent. So many states, particularly military states, refused to ratify the Additional Protocol 1. President Reagan described it as fundamentally and irreconcilably flawed, partly because of the way that it defined combatants. And this continued for decades. However, towards the end of the 20th century, ratifications began to increase of Additional Protocol 1, and the ICRC and other legal commentators started to describe it as customary international law. So as such, these provisions that were drafted in the context of the conflicts and the concerns of the 1970s have become entrenched in international humanitarian law, and they are now considered to be customary international law.
Thank you, Dr. Amanda. Our second speaker is Dr. Victor Kattan. Dr. Victor is Senior Research Fellow at the Middle East Institute at the National University of Singapore, which is here. And he's one of the major intellectual members of our community here. He further also serves as an Associate Fellow at the NUS Law Faculty. Dr. Victor is the author of numerous articles in international law journals and the author of 2 books, the latter of which is From Coexistence to Conquest, International Law and the Origins of the Arab-Israeli Conflict, published in 2009, as well as The Palestine Question in International Law that came out in 2008. Dr. Victor has taught several courses at Yale and US College, which is the other campus across the highway, at the NUS Law Faculty, as well as at the Center for International Studies and Diplomacy at SOAS in London. In 2019, Dr. Victor was announced the winner of the Asian Society of International Law Younger Scholar Prize. I'm glad it's younger and not young. Very nice title. In addition, he regularly writes for newspapers and other outlets, and he's an occasional contributor to Haaretz, the longest-running print newspaper in Israel. Dr. Victor's paper today is titled The Third World is the Enemy, Arguing About the Laws of War After the Fall of Saigon.
Thank you, Sinja. Good afternoon. As you might gather from my title, my argument today is that as a result of the decolonization progress, certain states did not like the look and orientation of the United Nations and the way in which international law was evolving at the United Nations, particularly with regard to, as Amanda's been speaking about, the additional protocols to the Geneva Conventions, but also the evolution of customary international law. So my argument will be that as a result, and I think the Vietnam War and the wars in the Middle East played a major role in provoking these changes, and as a result, as we move into the 1980s and the 1990s and up to the present, we see small groups of states, so-called like-minded states, breaking away from the UN, forming subgroups of diplomats and lawyers and articulating a different kind of international law. So this is connected to other projects I've worked on, including an article I published earlier this year on the so-called Bethlehem Principles, which were published in the American Journal of International Law in 2012, which tried to come up with a new definition of an imminent threat, which in my view would repudiate completely the Article 51 of the UN Charter. At the same time, we've seen the United States and Israel have still not ratified, or should I say, acceded to either of the additional protocols. So my talk, if you like, will be looking at what happened following the Vietnam War and the wars in the Middle East. So the first panel, if you like, was the 1960s, and we spent a lot of time in the 1970s, and I'm going to be looking at the 1980s, arguing that these developments were quite influential at the time. And I think we can also see these efforts this is why I was asking questions earlier this morning about whether whether governments took international lawyers seriously in the 1960s, because by that question I didn't mean that they weren't deliberately committing violations of international law, but at least they tried to construct a narrative that was plausibly consistent with the UN Charter. We've now reached the point today where President Trump can order a strike on Syria and not even reference the UN Charter at all. And I would argue this process, this degradation, if you like, of the UN Charter has been happening over a number of years. And one of these key moments, I argue, is 1984. This was a year following the bombings of the US Marine Corps barracks in Beirut, when there was intense policy discussions in the United States about what to do. So this photograph is showing you a picture of now retired, a recent photograph of George Shultz, who was the Secretary of State in the Reagan administration, and of course Benjamin Netanyahu, who's currently Israel's Prime Minister. And during the 1980s, there was an intense policy debate between the Pentagon and the State Department about how to deal with violence from non-state actors, and what they would call terrorist groups, or what others in the Third World would call national liberation movements, namely the PLO, which had been involved with a number of incidents in the Mediterranean at the time, and also a lot of groups associated with the Islamic Republic of Iran, the predecessor to Hezbollah, etc., in Lebanon. And it's around this time where if you read Schultz's memoirs, so he published them in the early 1990s, but he's reflecting on events in the 80s, he goes so far as to describe the UN Charter as a suicide pact. And what he meant by that is, Article 51, if you read it literally, it says that, states only have a right of self-defense if an armed attack occurs. And he said, well, why should we wait for an armed attack to take place? Why should we not be able to strike first? If we just follow what the UN Charter says, this could lead to national suicide. If think of weapons of mass destruction or nuclear weapons. So for me, this idea that the UN Charter had to be interpreted in a flexible way originated in reaction to the guerrilla struggles in Asia, North Africa, and the Middle East in the 1960s and 70s, although we really start to see the discourse change in the 1980s. And in fact, I've just published a piece which looks at the drafting of the Bush Doctrine in the National Security Strategy of 2002. And my argument is the key players involved in drafting that were influenced by developments in the 1980s. So if you like, what I'm trying to do now is go back further, reverse engineer, and go back to the 1980s. So I'm going to look at two issues. One is obviously Article 51 of the UN Charter, and then the other one is Additional Protocol 1. Both have been mentioned already in discussions today. And the way I'll try and do this is by comparing debates on Article 51 of the Charter to that took place in the 1980s and since then to those that had occurred in the 60s when the UN Charter was invoked as a legal basis for the US intervention in the collective self-defense of South Vietnam. And then I'll look at debates on Additional Protocol 1, looking at the arguments that were raging inside the Reagan administration as to why the US would not ratify additional Protocol 1, and the reason was because it was perceived by certain individuals to extend the protection of international humanitarian law to wars of national liberation. In other words, the UN Charter now reflected or was interpreted in a way that favored third world anti-colonial struggles. Okay, so we saw this morning, so this is a picture, it's missing something, but anyway, this is a photograph of the first page of the legal advice that was drafted by Leonard Meeker, the second one, not the first one, in reaction to what we heard from Madeleine Chiam about was it the Lawyers Committee on Vietnam criticized the first draft, so they came up with a better draft. And this draft was published in the Yale Law Review, and it was published in the American Journal of International Law. And we also heard from Brian that Leonard Meeker came up with an argument to justify the U.S. intervention in Vietnam as one of collective self-defense instead of one of reprisal, which was how it was going to be characterized originally. And the argument was, well, reprisals are unlawful, so why don't you make an argument based on collective self-defense. So reading this, I thought this was intriguing because there seems to be, whether it's persuasive or whether it's well written, it is at least an attempt to come up with, craft a legal argument that could be considered consistent with the UN Charter. One could question the facts, if you like, but legally he's looking at what the Charter would allow a country to do. Of course, it's based on the fiction of there being two Vietnams. It assumed that there were these guerrilla attacks being launched from the north to the south across DMZ that would amount to an armed attack. But if we were to take the document at face value, in other words, if we were to assume the facts were correct, there's nothing, I mean, it's plausible. It's a plausible argument, and it's not, and this is very different to what Schultz is saying, right? 20 years later, he's saying the whole thing is a waste of time, you know. We shouldn't even bother with the UN Charter. We have an inherent right of self-defense, and we're going to take action if we believe we need to, even if it's preventive, which I think is something quite different. It's a different way of different language, if you like, to the language I think that we saw pre-Vietnam War, or at least the early stages of the Vietnam War. So I was also interested in. Well, Brian, you said that you thought this shift occurred with Nixon in terms of this kind of less respect for the law. And so I think a key moment where the mood, if you like, changes is in the 70s. And so in the 1970s, we start to see, obviously, the number of African and Asian countries becoming members of the United Nations increased a lot in the 60s and 70s. And so we start to see a different mood in the UN. And in 1970, we see the Declaration on Principles of International Law concerning friendly relations and cooperation among states be adopted by the UN General Assembly. This language of self-determination, this kind of very vague language that people could have a right, you know, in their anti-colonial struggles to overthrow imperialism. They were allowed to receive aid and assistance from other countries. And we see now the drafting of the Apartheid Convention. There's even a definition of aggression, and then there's the Diplomatic Conference on International Humanitarian Law. The PLO is given observer status in the UN, and they're invited to participate in the drafting of these protocols. Even the Viet Cong was almost, there was a vote. So on its admission, they only lost by one vote. So you could have actually had a situation where the Viet Cong were taking part in developing international law. And so I see a reaction to this, an angry reaction in the United States. And you can see this in the debate between Richard Falk and Eugene Rostow at the American Society of International Law, where Richard Falk is arguing, the Americans, he's arguing, clearly lost the war. This is around 1973. This is the Paris Peace Accords. We should accept the peace accords. And Eugene Rostow is like lamenting that international law seems to be changing, and that it used to be the law that during a civil war, other states would not provide support to the insurgents, only to the lawful government. Now international law seems to have changed in this regard, and it was very dangerous, and there's a doctrine of self-determination, and the PLO are relying on this. Hitler had relied on this doctrine once. The law is all going wrong, and I don't recognize it. And so I think a real change occurs, and as a result of this, these changes, we see, if you like, a counter-revolution, if you call it like that. We see certain lawyers, particularly in the US government, but I imagine also elsewhere, perhaps in the UK and also in Israel, other countries, if you like, were facing guerrilla warfare activity reacting to these changes. But we see it clearly in the debates on the additional protocols. Again, I don't know why, we're missing a lot of text here, but so this is a photograph of W. Hayes Park, who's a professor of international law at the Army JAG School and a combat Marine veteran of the Vietnam War. Now, what happens is, in the 1970s, the US actually signs Additional Protocol 1, the Carter administration. So they didn't ratify it, but there was an intention to ratify it. The letter of transmittal to the Senate is sent, but there's a delay. Carter lost the elections to Reagan. I don't think he was expecting to lose. And there's a delay. There's a new government, there's a new administration, and Ronald Reagan comes with a very different rhetoric. And he brings in people into the government that have a very different view to previous US officials. So you've got people like Jean Kirkpatrick at the UN and her lawyer Alan Gerson. Then you get Schultz at the State Department and Abraham Safar at his lawyer. And then in the Pentagon you've got Richard Pearl and Douglas Feith. And then the head of the US Army JAG School is Hayes Park. Now these are, if you like, people who are very angry about what's been happening at the United Nations. And there's a concerted effort to, if you like, dampen down this kind of decolonization, pro-self-determination rhetoric. Now, in their view, national liberation struggles are basically terrorist movements. They are totally illegitimate, and they are not, and we see also there's a Nicaragua case, the US pulling out of that case, not even defending it on the merits. So essentially and I argue this in a paper I've submitted to a journal, which I'm hoping will be accepted, or otherwise I would have mentioned it, but it's, in the article I argue that these Vietnam War veterans like Hayes Parks and, if you like, people who, neoconservatives like Alan Gerson, Abraham Safar, Douglas Feith, if you like, get together and essentially persuade the President Reagan to oppose ratification. This is clear from both public documents from the period, also from the memoirs of Alan Gerson and Douglas Feith, and also some archival documents I've seen in the Reagan Presidential Library. And again, it's this argument that Additional Protocol 1 has in some way legitimized wars of national liberation. And there were lawyers who were arguing at the time that it didn't really do that, that these, for instance, if a national liberation movement wanted to, it would have to show that it would abide by international law. It would have to issue a declaration, I think it's Article 96.1 or 96.2, stating that they would abide by the additional protocols. It wasn't automatic. These guys didn't. For them, it was clear that this was purely ideological, in the sense that this was a bad thing. Do not accede to it. They were also opposed to other conventions, like the Convention on the Law of the Sea. So we see, if you like, a reaction to this. And another name that's been mentioned today, I think had been mentioned, is John Norton Moore, who was very pro-Vietnam War, and published a lot of work on the Arab-Israeli conflict. I think his 2-volume set on documents on the Arab, or 3-volume set on documents of the Arab-Israeli conflict is still one of the best documents out there. But he published a book, which is quite intriguing. It's called Deception and Deterrence in Wars of National Liberation, State-Sponsored Terrorism and Other Forms of Secret Warfare. And Hayes Parks and all these other people I mentioned publish articles in this. It's published in 1997, but it's based on the 1980s. And again, so if you look at the group of lawyers, you can see that they are happy with this role of the Third World. And in a nutshell, okay, good. Ronald Reagan ends up deciding not to ratify the additional protocol. And there's this quite interesting quote where he goes on to say, "We cannot allow other nations of the world, however numerous," I like to emphasize however numerous, "to impose upon us and our allies and friends an unacceptable and thoroughly distasteful price for joining a convention drawn to advance the law of war. fact, we must not and need not give recognition and protection to terrorist groups as a price for progress in humanitarian law. So he's quite clear that liberation movements in the 70s are now terrorist groups in the 1980s. So to conclude, my concluding thoughts are that I think maybe I agree with Amanda in this sense. In the sense that I think there was a big cultural shift in the 1970s, but paradoxically, my conclusion is that one of the consequences of using law of war terminology by anti-war activists was that it led to resistance to the transformation of international law during decolonization by certain key players, namely the US, Israel, and I'll chuck in the UK, Australia, and Canada since then. So if you look at their current discourse on especially preventive war, they're moving, in my view, far, far from the UN Charter. All right, I'll leave it there, and I'm happy to have any discussions with you. Thank you.